Welcome to part 2 of your New Jersey Real Estate Study Guide. This is one of the most tested areas on the exam. Today, we'll make it click. In this video, we'll cover estates and land, shared ownership, tenancy by the entirety, common interest communities, trusts, estates, and business entities, life estates. And remember, our website offers free exam guides and practice questions to help you prepare for and ace your New Jersey real estate exam. Be sure to check the link below so you can access all the resources you'll need. Study smarter, stay confident, and get ready to pass with flying colors. All right, let's get started. Let us begin with the idea of an estate. An estate is the degree, nature, and extent of your interest in land, and it splits into two families. Freehold estates last for an indeterminate time and carry legal possession. Leasehold estates give possession for a fixed period, like a lease or periodic tenancy. The star of the freehold family is fee simple absolute. Honestly, this is the one I would lock in first because it is the highest estate American law recognizes. It lasts potentially forever. You can sell it, will it, or leave it to your heirs. Limited only by government powers and recorded encumbrances. But not every fee simple is unconditional. A fee simple defeasible is ownership tied to a condition, and if that condition is broken, the owner can lose title. A fee simple determinable ends automatically the instant the condition fails. A fee simple on condition subsequent does not end on its own. Someone must step in and reclaim it. Picture a family in Montclair that donates a corner lot to the town so long as it is used as a public library. That phrase, so long as, creates a determinable fee that reverts automatically if the library closes. Listen for the trigger words. So long as and until mean automatic reversion, while but if means the grantor must act. Now shift from how long you own to how many of you own. Ownership in severalty means ownership by exactly one person or one legal entity. Despite the word, it does not mean severed among many. It means your interest stands alone, cut off from any co-owner. A single person or company qualifies. Why choose severalty? The appeal is total control. You decide when to sell, refinance, or lease with nobody to consult. But the trade-off is real. When a sole owner dies, the property must travel through their estate and creditors can reach it fully. Remember that severalty and sole ownership mean the same thing. What we just worked through is exactly the kind of material sitting in our free practice question bank. And these are not shallow questions. They are written to test the deep distinctions we are drawing right now, the same way the New Jersey exam will push you to tell one estate from another. Now, this is where it gets interesting because most people do not own alone. When two or more people share title at the same time, we call it concurrent ownership. The first form is tenancy in common. Here, each co-owner holds an undivided fractional share, yet each has the right to use the whole property, not merely their slice. Tenancy in common has a few signature traits worth memorizing. The shares can be unequal, so one owner might hold 60% and another 40%. There is no right of survivorship, the big one. When a tenant in common dies, that share passes by will or to their heirs, never to the other owners. Each share is freely transferable. Here is a point New Jersey loves to test. When two or more unmarried people take title and the deed omits the form of ownership, New Jersey presumes a tenancy in common, not a joint tenancy. So if two friends buy a duplex in Jersey City and record a silent deed at the Hudson County Register of Deeds, they are tenants in common. So what happens when co-owners cannot get along? Any tenant in common can ask a court for partition, a forced division of the property. Imagine 3 siblings who inherit a shore house in Cape May and cannot agree on its future. A court can order partition in kind, splitting the land, or partition by sale, dividing the proceeds. Joint tenancy takes co-ownership in a different direction. Here, two or more people hold equal, undivided interests, and the defining feature is the right of survivorship. When one joint tenant dies, that interest passes automatically to the survivors. Outside of probate, that single feature, survivorship, decides who inherits when an owner dies. Joint tenancy only exists if four unities are present at creation. They are possession, interest, time, and title, remembered with the word PRTT. All owners must share possession of the whole, hold equal interests, take title at the same time, and take it through the same single document. Break any one unity and the joint tenancy collapses. Let me show you severance in action. Suppose three people own a rental as joint tenants and one sells her third to an outsider. That sale destroys the unities for her share, so the buyer becomes a tenant in common. The remaining two still hold their 2/3 as joint tenants between themselves. The joint tenancy survives, just smaller. And here is the part most students miss. Death does not sever a joint tenancy. Death triggers the survivorship. The decedent's heirs receive nothing of that property, which surprises families all the time. The classic trap describes a joint tenant dying and asks what the children inherit. For that property, the honest answer is nothing at all. I know we are covering a lot of fine distinctions, and you might wonder how to practice applying them. That is exactly why I built those free practice questions. They let you work through ownership scenarios that blend these forms together, so the differences move from your notes into your instincts. Now we reach a topic New Jersey tests harder than almost any other: tenancy by the entirety. Think of it as a special upgraded joint tenancy reserved only for legally married spouses and civil union partners. New Jersey is a strong entirety state, so this form carries protections you will not find in an ordinary joint tenancy. New Jersey's tenancy by the entirety statute lays out how it forms. It arises when spouses or civil union partners take title together under a written instrument that names them as such. And here is the presumption you must know. When a deed names a married couple as buyers without specifying the form, New Jersey presumes tenancy by the entirety. You already know the four unities of joint tenancy. Tenancy by the entirety adds a fifth, the unity of marriage. So alongside possession, interest, time, and title, the couple must be lawfully married or in a civil union when they take the interest. That is why some call it the 5-unity tenancy. Marriage is what sets it apart. Here is the single most important distinction and a favorite on the exam. Neither spouse can unilaterally sever, sell, mortgage, or encumber entirety property without the written consent of the other. Picture a married couple in Cherry Hill who own their home this way. One spouse cannot quietly mortgage it alone. A joint tenant, by contrast, could. The consequences for creditors are just as striking. A creditor of only one spouse generally cannot seize entirety property to satisfy that spouse's individual debt. Say one partner runs up a personal business debt alone. The creditor cannot force a sale of the marital home. At most, it reaches that spouse's uncertain survivorship interest. How does tenancy by the entirety end? 3 ways. First, the death of one spouse, where the survivor takes full title. Second, divorce or annulment, which converts it into a plain tenancy in common. Third, a mutual written agreement to convey together. These protections apply to property acquired on or after early April of 1988. This is also the moment to bury 2 old common law terms. Dower was a widow's life estate in 1/3 of her husband's land, and courtesy was the husband's version. New Jersey abolished both for property acquired on or after late May of 1980. In their place, each spouse gets joint possession of the marital home. Do not overlook who qualifies. Since New Jersey recognizes civil unions, those partners may hold title by the entirety on the same terms as married couples, and same-sex spouses stand on equal footing. A classic trap offers tenancy by the entirety for two unmarried business partners. That is always wrong. Marriage or civil union is mandatory. If you take one thing from this section, make it this. Tenancy by the entirety equals marriage plus the impossibility of acting alone. That pairing, spouses only and no unilateral moves, unlocks nearly every question they can ask. In my experience, this is where careful students pull ahead because they grasp why entirety property is so protected. If some of these entirety rules feel dense right now, please do not worry. That reaction is normal, and it is exactly why the comprehensive practice question bank exists. Working through real scenarios is how these protections stop feeling abstract and start feeling obvious. Every single question comes completely free. Let us move into shared communities, condominiums, cooperatives, and timeshares. What ties them together is one idea. You own or control your own unit while also holding an interest in property shared with everyone else. In New Jersey, these communities fall under the Planned Real Estate Development Full Disclosure Act, requiring registration and a public offering statement. Start with the condominium, the form most people picture. In a condo, you hold full fee, simple title to your individual unit, the space you live in. On top of that, you own an undivided share as a tenant in common of the common elements. Those are the lobbies, hallways, roof, elevators, grounds, and recreation areas everyone shares. New Jersey governs these under its Condominium Act, and one document brings a condominium to life, the master deed. Recording that master deed with the county recording officer legally creates the condominium. So when a developer converts an old warehouse in Hoboken into condos, it is not truly a condominium until that master deed reaches the Hudson County Register of Deeds. Within a condo, separate common elements from limited common elements. General common elements belong to everyone, like the roof and the lobby. Limited common elements are reserved for one or a few owners, even though they remain common. Your assigned parking space, private balcony, and storage locker are the classic examples. They serve you alone. Every New Jersey condominium is run by an association, the community's government. It adopts bylaws, levies common expense assessments against each unit to pay shared costs, buys insurance, and enforces the rules. When an owner stops paying assessments, the association can place a lien on that unit, which leads to a powerful New Jersey rule. This one wins exam points, so lock it in. In New Jersey, the association's lien for the 6 most recent months of unpaid assessments jumps ahead of a prior recorded first mortgage. We call it the 6-month super lien. It is a deliberate exception to the usual first in time, first in right rule. Cooperatives work in a completely different way, and the distinction is a favorite test point. In a co-op, a corporation owns the entire building, so you do not own real estate at all. Instead, you buy shares in that corporation, and those shares come with a proprietary lease to occupy your apartment, so the owner holds personal property. That single difference drives everything else. A condo owner receives a recorded deed, while a co-op owner receives an assignment of stock and a lease. Cooperatives are far more common in New York City than in New Jersey, though they exist here, especially in towns like Fort Lee. New Jersey even has a Cooperative Recording Act. Timeshares are the third community form, giving a buyer the right to use a unit for a set period each year, often a single week. They come in 3 shapes. A deeded timeshare conveys a real property interest. A right to use timeshare is only a contract, so it is personal property. A points-based plan spans many resorts. New Jersey protects timeshare buyers through its Real Estate Timeshare Act. Every purchaser gets the right to cancel within 7 calendar days after the later of signing the contract or receiving the public offering statement, and that right cannot be waived. Picture a couple who buys a week in Wildwood on a Saturday. They have a full 7 days to walk away. Remember, mastering these community forms takes repetition, not a single pass. The free practice questions are built precisely for that. They take what you are learning here and turn it into exam-ready reflexes, so that condo versus co-op or the super lien rule comes back to you instantly on test day. Now, let us talk about owning property through a trust. A trust is a legal arrangement with 3 roles. A settler creates it and places property inside. A trustee holds legal title and manages that property. And a beneficiary enjoys the benefits. So the trustee holds legal title while the beneficiary holds equitable title. Ownership is divided on purpose. Several kinds of trusts show up on the exam. A revocable living trust can be changed or undone by the settler at any time. An irrevocable trust cannot be touched once created, which shields the assets. A testamentary trust is born from a will after death. There is also the real estate investment trust, coming shortly. The revocable living trust is the workhorse of estate planning, so let me make it concrete. A homeowner in Princeton deeds her house into her own revocable trust and names herself as trustee. She keeps full control during life, but when she dies, the home passes straight to her beneficiaries without probate. That probate avoidance is the whole appeal. When an owner dies, their real property becomes part of their estate, managed by a personal representative. If a will names that person, we call them the executor. If there is no will or no named executor, the court appoints an administrator. In New Jersey, this runs through the County Surrogates Court, which admits wills and oversees estates. What happens when someone dies with no will at all? New Jersey's intestate succession laws decide who inherits. A surviving spouse or civil union partner often takes the entire estate, especially when all the children are shared. There is also a subtle survival rule. A person must outlive the decedent by at least 120 hours. New Jersey also refuses to let a spouse be completely cut out of a will. Through the elective share, a surviving spouse, civil union partner, or domestic partner may claim 1/3 of the augmented estate instead of accepting a stingy will. The election must be made within 6 months of the personal representative's appointment. Here is a New Jersey quirk worth a nearly guaranteed point. Many states allow a transfer on death deed, sometimes called a beneficiary deed, that passes real estate at death outside probate. New Jersey has not adopted it. So if a question offers a transfer on death deed for New Jersey real property, be skeptical. Property is often owned by a business rather than a person, so know the entity forms. A sole proprietorship is not a separate entity. The owner holds title in their own name with unlimited personal liability. A general partnership is 2 or more people in business together, with every partner personally liable for the debts. The safer entities add liability protection. A limited partnership pairs general partners who manage and stay liable with passive limited partners who risk only their investment. A limited liability company blends that protection with tax flexibility, and it is the dominant vehicle for investment real estate in New Jersey. A corporation is fully separate from its shareholders. Finally, the Real Estate Investment Trust, or REIT, lets ordinary investors pool money into income-producing property. To qualify for its tax advantages, a REIT must meet strict tests, including paying out at least 90% of its taxable income as dividends. A common trap treats a REIT like an ordinary trust. It is a tax-favored company. As we move toward the finish, keep this in mind. Understanding these forms is only the first step. Real mastery comes from applying them under pressure, which is where those free practice questions earn their keep. They are completely free, built for New Jersey exam success, and waiting in the description right now. Our final major topic is the life estate, and it is more elegant than it first appears. A life estate is a freehold estate whose duration is measured by someone's lifetime. The person holding it is the life tenant, and when that measuring life ends, so does the estate. It is genuine ownership with a built-in expiration. There are two versions to separate. A conventional life estate is measured by the life tenant's own life, as in to Maria for life. A life estate per ultra V is measured by someone else's life, as in to Maria for the life of Carlos. In that case, Maria holds the estate, but Carlos's lifespan is the clock. Something always waits to take over when a life estate ends. If the property passes to a named third person, that person holds a remainder. To Anna for life, then to Brian, gives Brian a remainder. A remainder is vested when the taker is known, or contingent when it depends on a condition. Otherwise, it reverts to the grantor. Here is the classic example. To my sister Anna for life, then to my nephew Brian. Anna is the life tenant, and Brian holds a vested remainder. Suppose Anna sells her interest to a neighbor in Morristown, who then holds only a life estate measured by Anna's life. When Anna dies, it still goes to Brian. A life tenant enjoys real rights during the estate. She may possess and use the property, collect its rents and profits, and even mortgage, lease, or sell her interest. But there is a natural ceiling. She can only convey what she has, an estate lasting for her lifetime. A buyer simply steps into her shoes. With those rights comes a duty not to commit waste, meaning harm to the future owner's stake. Voluntary waste is active destruction, like tearing out valuable fixtures. Permissive waste is neglect, like letting the roof rot or failing to pay taxes. Ameliorative waste is a change that improves the property, which modern courts usually forgive. The life tenant's duties are practical and testable. She must pay the property taxes, cover the interest on any mortgage, make ordinary repairs, and keep the property insured. Say Anna stops paying her property taxes and lets a tax say loom. That is classic permissive waste, and Brian, holding the remainder, can sue to protect his interest. Where do life estates actually show up? Most often in estate planning. A parent deeds the family home to the children but keeps a life estate, so the parent lives there for life, and the children take over automatically at death, skipping probate. Here is my honest take. Find the measuring life, and everything else falls into place. Take a breath, because you have covered enormous ground today. We started with estates in land and fee simple ownership, then moved through severalty, tenancy in common, and joint tenancy with its 4 unities. We spent real time on tenancy by the entirety, the heavily tested marital form that cannot be severed alone. Each rewards the small distinctions. From there we explored condominiums with their master deeds and super liens, cooperatives with their shares and proprietary leases, and timeshares with that 7-day cancellation right. We unpacked trusts, estates, and the surrogates court, surveyed the business entities that hold property, and closed with life estates. Notice how survivorship and the measuring life keep returning. You are far more prepared than you were an hour ago, so let us turn knowledge into results. Grab those free practice questions in the description and put every concept to work. Answer them, miss a few, and learn from them. Do that and you will walk into your New Jersey exam ready. That wraps up part 2 of our look at property ownership. If you'd like to practice what we covered, visit our website. the links right in the description below. There you'll find hundreds of free practice questions plus complete detailed study guides on every topic. Everything you need to keep learning is waiting, so dive in and get started today. Subscribe so you don't miss the next part, and good luck on your exam.